Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time, and it's our goal to be with you from day one until you pass the bar exam. Don't forget to like, subscribe, and click the notification bell so that you can be updated every time we upload new content. Let's start with question number 1. Alex and Brenda owned in fee simple Greenacre as tenants in common, each owning an undivided 1/2 interest. Alex and Brenda joined in mortgaging Greenacre to Marge by a properly recorded mortgage that contained the general warranty clause. Alex became disenchanted with landowning and notified Brenda that he would no longer contribute to the payments of the installments due to Marge on the mortgage. After the mortgage was in default and Marge made demand for payment of the entire amount of principal and the interest due, Brenda tendered to Marge, and Marge deposited a check for 1/2 of the amount due Marge. Brenda then demanded a release of Brenda's undivided 1/2 interest. Marge refused to release any interest in Greenacre. Brenda promptly brought an action against Marge to quiet title for the undivided 1/2 interest in Greenacre. In such an action, Brenda should A. Lose because Marge's title had been warranted by an express provision of the mortgage. B. Lose because there was no redemption from the mortgage. C. Win because Brenda's entitled to marshalling. D. Win because the co-tenancy of the mortgagors was in common and not joint. Take 10 seconds and see if you can figure out what the best answer is. If you chose option B, you'd be correct, lose, because there was no redemption of the mortgage. Let's think this question through a little bit. Regardless of how Alex and Brenda had their arrangement in fee simple, whatever it may be, they took initially from a mortgage, obviously. They purchased through the vehicle of a mortgage. They had an obligation to the mortgage. Now, that being said, regardless of what their obligation to one another is, the obligation to the mortgage still exists. Under the common law right of redemption, for example, while the foreclosure is in progress, a mortgage debtor has the right to redeem the property from the mortgage by paying the full amount past due on the mortgage, including interest and attorney's fees. Brenda here would lose because she paid her portion, so there's been no redemption. And at the end of the day, regardless of what agreement they had, Alex and Brenda amongst themselves, it would not affect what is due to the mortgager. So as a result, B would be the correct answer. Brenda would lose because there was no redemption from the mortgage, and the mortgage was still fully intact and in place with 50% of the debt still owed because that was not paid. Let's move on to question number 2. Fran, who was driving at excessive speed, applied her brakes to stop at a traffic light. Due to damp fallen leaves, her car skidded and came to a halt perpendicular to the roadway. Sid, who was also driving at excessive speed and was immediately behind Fran, saw Fran's car perpendicular to the roadway. Although Sid had sufficient distance to come to a slow, controlled stop, he decided not to slow down, but rather to swerve to the left in an effort to go around Fran's car. Due to oncoming traffic, the space was insufficient, and Sid's car collided with Fran's car, severely injuring Fran. Fran filed a personal injury action against Sid in a jurisdiction in which contributory negligence is a bar to recovery. Will Fran prevail? Option A. Yes, if the jury finds that Sid was more than 50% at fault. B. Yes, if the jury finds that Sid had the last clear chance. C. No, if the jury finds that Fran's conduct was in any way a legal cause of the action. Or D, no, if the jury finds that, in speeding, Fran assumed the risk. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Yes, if the jury finds that Sid had the last clear chance. Under the traditional common law contributory negligence doctrine, if the plaintiff was also negligent, that plaintiff is completely barred from recovery. The last clear chance doctrine, however, is a limit on the defense of contributory negligence. If the defendant had an opportunity to prevent the harm, just before the accident, and the plaintiff did not, the plaintiff will not be barred from recovery. In this case, Fran is clearly negligent. She was driving at an excessive speed, so she would be completely barred in a jurisdiction in which contributory negligence is a bar to recovery, unless Sid had the last clear chance. If we look at the fact pattern, Sid made the conscious decision not to slow down, although he had ample time to do so. Thinking that he was in a NASCAR pileup instead, he decides to swerve to the left. That being said, it was his final decision, although he had ample opportunity to avoid the accident, which in essence causes a secondary accident, which as a result would not bar Fran from collecting. Let's look at question number 3. Buyer Inc. contracted in writing with shareholder who owned all of XYZ Corporation's outstanding stock to purchase all of her stock at a specified price per share. At the time this contract was executed, buyer's contracting officer said to shareholder, "Of course our commitment to buy is conditioned on our obtaining approval of the contract from Conglomerate Limited, our parent company." Shareholder replied, "Fine, no problem. For this question only, assume the following facts. Shareholder is willing and ready to consummate the sale of her stock to buyer, but the latter refuses to perform on the ground that Conglomerate has firmly refused to approve the contract. If shareholder sues buyer for breach of contract and seeks to exclude any evidence of the oral condition requiring Conglomerate's approval, the court will probably A. Admit the evidence as proof of a collateral agreement, B. Admit the evidence as proof of a condition to the existence of an enforceable obligation and therefore not within the scope of the parole evidence rule, C. Exclude the evidence on the basis of a finding that the parties' written agreement was a complete integration of their contract, or D. Exclude the evidence as contradicting the terms of the parties' written agreement, whether or not the writing was a complete integration of the contract or not. Take 10 seconds and choose the best option. If you chose option B, you'd be correct. Admit the evidence as proof of a condition to the existence of an enforceable obligation and therefore not within the scope of the parole evidence rule. The parole evidence rule states that no prior expressions, written or oral, or contemporaneous oral statements are admissible. For the parole evidence rule to apply, there must be an integration within the actual agreement. Parole evidence, however, is admissible to show the existence of a condition precedent. In this case, the condition is not in fact a portion of the contract, but instead deemed a condition precedent because there would be no contract but for that initial agreement and that initial term. Question number 4. A federal statute provides that cities in which certain specified airports are located may regulate the rates and services of all limousines that serve those airports, without regard to the origin or destination of the passengers who use the limousines. The cities of Redville and Greenville are located adjacent to each other, but in different states. The airport serving both of them is located in Redville, and is one of those airports specified in the federal statute. The Redville City Council has adopted a rule that requires any limousines serving the airport to charge only the rates authorized by the Redville City Council. Airline limousine service has a lucrative business transporting passengers between Greenville and the airport in Redville at much lower rates than those required by the Redville City Council. It transports passengers in interstate traffic only. It does not provide local service within Redville. The new rule, adopted by the Redville City Council, will require airline limousine services to charge the same rates as limousine operators only in Redville. Must airline limousine service comply with the new rule of the Redville City Council? Let's look at our options. A, yes, because the airport is located in Redville, and therefore the City Council has exclusive regulatory authority over all transportation to and from the airport. Option B, yes, because Congress has authorized this form of regulation by Redville and therefore removed any constitutional impediments to it that may otherwise have existed. Option C, no, because the rule would arbitrarily destroy a lucrative existing business and therefore would amount to a taking without just compensation. Or D, No, because airline limousine service is engaged in interstate commerce, and this rule is an undue burden on that commerce. Take 10 seconds and choose the best answer. If you chose option B, you'd be correct. Yes, because Congress has authorized this form of regulation by Redville and therefore removed any constitutional impediments to it that may have otherwise existed. If the Congress has not acted, a state or local government may regulate local aspects of interstate commerce, unless the state or local laws discriminate against out-of-staters or place an undue burden on interstate commerce. However, if the Congress approves the state or local law, then it will be upheld even if it discriminates against out-of-staters or places an undue burden on interstate commerce. In this case, the rule adopted by the Redville City Council places an undue burden on interstate commerce by requiring that any limousines serving the Redville Airport charge only the rates authorized by the Redville City Council. This undue burden on interstate commerce is permissible because Redville City is authorized by federal statute to regulate the rates and services of all limousines that serve the Redville Airport. As such, airline limousine services must comply with the new rule because Congress has authorized this form of regulation by Redville and therefore removed any constitutional impediments to it that may have existed otherwise. Question number 5, we're halfway through. Plaintiff sued defendant Auto Manufacturing for his wife's death, claiming that a defective steering mechanism on the family car caused it to veer off the road and hit a tree when his wife was driving. Defendant claims that the steering mechanism was actually damaged in the collision and offers testimony that the deceased wife was intoxicated at the time of the accident. Testimony concerning the wife's intoxication is A. admissible to provide an alternate explanation of the accident's cause. B. admissible as proper evidence of the wife's character. C. inadmissible because it is improper to prove character evidence by specific conduct. Or D. inadmissible because it is substantially more prejudicial than it is probative. Take 10 seconds and choose the best option. If you chose option A, you'd be correct. Admissible to provide an alternate explanation of the accident's cause. Evidence is legally relevant if its probative value outweighs its unfair prejudice. All evidence is prejudicial to one party. However, and this rule will only exclude it if the prejudice substantially outweighs the probative value. In this case, plaintiff's claims that a defecting steering mechanism on the family car caused it to veer off the road. Defendant offers testimony that the deceased was in fact intoxicated at the time of the accident as an alternate explanation. The probative value here greatly outweighs any unfair prejudice it may have. Thus, the testimony concerning the wife's intoxication is admissible to provide an alternate explanation of the accident's cause. Let's look at the 3 other choices. B and C have to do with character evidence. At the end of the day, in a matter such as this, character evidence would not generally be your best option, as in all likelihood, character evidence would have little to no implication on the outcome of the case before the court. And finally, D, inadmissible because it's substantially more prejudicial than probative. An alternate theory of the case is without question one of the exceptions or one of the situations where evidence of an alternate theory would be admissible, regardless of how prejudicial it may be. If you're looking at, let's say, a murder case, and in a Perry Mason style, you present facts that a different individual committed the crime, that would arguably be terribly prejudicial to that person. However, the prejudice is heavily outweighed by the fact that, in fact, it is addressing the underlying claims of the case. Here, in this situation, we're looking at the underlying fact, which the court is in actuality charged with deciding. How did the accident occur? If there's a different theory of how the accident occurred, then the court should hear it. Question number 6. Otis owned in fee simple lots 1 and 2 in an urban subdivision. The lots were vacant and unproductive. They were held as a speculation that their value would at some point increase. Otis died and by his duly probated will devised the residue of his estate, of which lots 1 and 2 were part, to Lena for life, with remainder in fee simple to Rose. Otis's executor distributed the estate under the appropriate court order and notified Lena that future real estate taxes on lots 1 and 2 were Lena's responsibility to pay. Except for the statutes relating to probate and those relating to real estate taxes, there's no applicable statutes that relate. Lena failed to pay the real estate taxes due for lots 1 and 2. To prevent a tax sale of the fee simple, Rose paid the taxes and demanded that Lena reimburse her for the same. When Lena refused, Rose brought an appropriate action against Lena to recover the amount paid. In such an action, Rose should recover A. The amount paid because a life tenant has a duty to pay current charges. B. The present value of the interest that the amount paid would earn during Lena's lifetime. C. Nothing, because Lena's sole possession gave the right to decide whether or not taxes should be paid. D. Nothing, because Lena never received any income from the lots. Take 10 seconds and choose the best answer. If you chose D, nothing, because Lena never received any income from the lots, you'd be correct. The life tenant must pay taxes on the land to the extent of the income or profits derived from the land, or, if none, to the extent of the reasonable rental value of the land. In this case, lots 1 and 2 were vacant and unproductive. As such, Lena had no obligation to pay the taxes on these lots. As a result, option D would be the best answer here. Question number 7. Employer retained doctor to evaluate medical records of prospective employees. Doctor informed employer that applicant, a prospective employee, suffered from AIDS. Employer informed applicant of this and declined to hire her. Applicant was shocked by the news and suffered a heart attack as a result. Subsequent tests revealed that applicant in fact did not have AIDS. Doctor had negligently confused applicant's file with that of another prospective employee. If applicant sued doctor for damages, on which of the following causes of action would applicant recover? 1. Invasion of privacy. 2. Negligent misrepresentation. 3. Negligent infliction of emotional distress. Please choose option A for just 3, option B for 1 and 2 only, option C 2 and 3 only, or D all of the above. Take 10 seconds and choose the correct answer. If you chose option A, you'd be correct. Negligent infliction of emotional distress only. The duty to avoid causing the negligent infliction of emotional distress to another is breached when 1. The threat of physical impact leads to emotional distress, or 2. There's a special relationship between plaintiff and defendant that is breached and directly causes severe emotional distress. The emotional distress must cause subsequent physical consequence, such as a heart attack. The applicant can recover for the negligent infliction of emotional distress because the duty to avoid causing the negligent infliction of emotional distress was breached by the doctor when he incorrectly informed the employer that applicant suffered from AIDS. Since this emotional distress caused subsequent physical consequences, the heart attack, applicant will be able to recover for the negligent infliction of emotional distress. Question number 8. Sam and 2 of his friends were members of a teenage street gang. While they were returning from a dance late one evening, their car collided with a car driven by an elderly woman. After an argument, Sam attacked the elderly woman with his fists and beat her to death. Sam's 2 friends watched, and when they saw the woman fall to the ground, they urged Sam to flee. Sam was eventually apprehended and tried for manslaughter, but the jury could not decide on a verdict. If Sam's companions are subsequently tried as accomplices to manslaughter, they should be A. Acquitted because Sam was not convicted of the offense. B. Acquitted because they did not assist or encourage Sam to commit the crime. C. Convicted because they urged him to flee. D. Convicted because they made no effort to intervene. Take 10 seconds and choose the best option. If you chose option B, you'd be correct. Acquitted because they did not assist or encourage Sam to commit the crime. An accomplice is someone who, with intent that the crime be committed, aids, counsels, or encourages the principal before or during the commission of the crime. Mere presence alone, however, is never enough for accomplice liability. An accessory after the fact, however, is someone who shields, shelters, or assists another, knowing that she has or he has committed a felony in order to help the felon escape arrest, trial, or conviction. The felony must be complete at the time aid is rendered for accessory after the fact liability to be pertinent. In this situation, the fact pattern tries to trick you by bringing up the fact that there's a teenage street gang. There's an assumption that comes along with that of violence and of other things. However, it's negated by the fact that you're informed that they're coming from a school dance. So that being said, the mere presence of the two other individuals at the scene with no other intervention is not sufficient for any liability. Question number 9. A federal statute with inseverable provisions established a new 5-member National Prosperity Board with broad regulatory powers over the operations of the securities, banking, and commodities industries, including the power to issue rules with the force of law. The statute provides for 3 of the board members to be appointed by the President with the advice and consent of the Senate. They serve 7-year terms and are removable only for good cause. The other 2 members of the board were designated in the statute to be the respective General Counsel of the Senate and House of Representative Committees on Government Operations. The statute stipulated that they were to serve on the board for as long as they continue in those positions. Following all required administrative procedures, the board issued an elaborate set of rules regulating the operations of all banks, security dealers, and commodities brokers. The Greenlight Securities Company, which was subject to the board's rules, sought a declaratory judgment that the rules were invalid because the statute establishing the board was unconstitutional. In this case, the court should rule that the statute establishing the non-prosperity board is A. Unconstitutional, because all members of federal boards have broad powers that are quasi-legislative in nature, such as rulemaking, must be appointed by Congress. B. Unconstitutional, because all members of federal boards exercising executive powers must be appointed by the President or in a manner otherwise consistent with the Appointments Clause of Article 2. C. Constitutional, because the necessary and proper clause authorizes Congress to determine the means by which members are appointed to boards created by Congress under its power to regulate commerce among the states. Or D. Constitutional, because there is a substantial nexus between the power of the Congress to legislate for the general welfare and the means specified by Congress in the statute for the appointment of the board. Take 10 seconds and choose the best answer. You'd be right if you chose option B, unconstitutional because all members of federal boards exercising executive powers must be appointed by the President or in a manner otherwise consistent with the Appointments Clause of Article 1. The President appoints all ambassadors, other public ministers and counsels, justices of the Supreme Court, and all other officers of the United States whose appointments are not otherwise provided for, with the advice and consent of the Senate. Congress, however, may vest the appointment of inferior officers in the President alone. The lower federal courts or the heads of departments, Congress is prohibited from delegating appointment power to itself or its officers. In this case, the members of the 5-member National Prosperity Board would be considered officers of the United States and must be appointed in a manner consistent with the Appointments Clause. However, 2 members of this board are designated by statute to be the respective General Counsel of the Senate and House of Representatives Committee of Governmental Operations. As such, this board cannot exercise executive powers, and the statute establishing the National Prosperity Board should be held unconstitutional. On to the last question in this grouping. Plaintiff Construction Company sued Defendant Development Company for money owed on a cost-plus contract that required notice of proposed expenditures beyond original estimates. Defendant asserted that it never received the required notice At trial, plaintiff calls its general manager, witness, to testify that it is plaintiff's routine practice to send costs over on notices as required by the contract. Witness also offers a photocopy of the cost over on notice letter to defendant on which plaintiff is relying and which he has taken from plaintiff's regular business files. On the issue of giving notice, the letter copy is A. admissible, though hearsay under the business record exception, B. admissible because of the routine practices of the company, C. inadmissible because it is hearsay, not with any exception, or D. inadmissible because it is not the best evidence of the notice. Take 10 seconds and choose the best option. If you chose option B, admissible because of the routine practices of the company, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is inadmissible because the declarant cannot be cross-examined when they speak out of court and without cross-examination. One cannot tell if the declarant is lying or mistaken about the facts in their statement. Again, however, this is only an issue if the statement is being used to prove those facts as true. As such, statements offered to show the effect on the listener and statements offered to show that the declarant knows the facts that are in the statement are not hearsay. Since the issue here is giving notice, not whether the information in the letter is true, the letter copy would be admissible as routine practices of the company. Thank you again for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam, 10 questions at a time. We upload content every morning at 8 a.m. Eastern Standard Time, so please like, subscribe, and click the notification bell so that you can be updated every time there's new content.